there was a story this week about America suing its own effectively. And as we know, the standard behavior is Europe legislates, America sues, and we kind of go around in this merry-go-round. But the table turned, America is suing its own. Florida just became the first state to take AI to court. Now, they're suing OpenAI and Sam Altman personally for an unsafe product off the back of a criminal probe tied to a campus shooting. The same week, Trump has watered down his AI order, but it's basically made the whole AI regulation control piece largely meaningless. For an example, they had this 90-day mandatory review. It's now become a voluntary 30-day review, just as Mythos is now going to another 150 companies across 15 countries to be tested and trialed in the wild. So what is happening with Florida suing? Should they win? Will they win?
I think it's an interesting development. I mean, one might question why push it down that litigious route at all, and when does suing work, and when does it break, and why is Anthropic different from cold pizza? And I think it's just the recognition that there's some things that can break, and then you can have a trial, and there could be remedies, and that is okay in some situations. And then there's some situations when it's not okay, when it's it's out of the bag. We don't want somebody to take down the safety controls of a nuclear power plant and for there to be a big meltdown and then rely on kind of a civil court case afterwards. Then it's too late. And so it's figuring out when is the harm bound to a sort of a more local issue that you can run a trial over, and when is it more unbound, where sort of once it's out of the bag, it's spreading and there's diffusion and it's too late. And I think it's figuring out which is which. And to some extent, I think that's what we're seeing now is regulators and politicians are trying to work that piece out.
Matt, have you got any thoughts on this one?
Not much to add beyond that. I think it's that, some of those fundamental things around what are those core guardrails, those non-negotiables, and then inside of that, I think we have a system that's quite well placed to iterate around errors.
I wonder if this will open up other lawsuits or open up other challenges. It just feels like a super weird thing for them to do.
I mean, another vector in this, Dan, is kind of the personal naming of Sam Altman in one of the trials. And the point there is, look, we have limitation of liability in our corporate codes for good reason. It's sort of load bearing to entrepreneurship that you're able to stand up a business and the business is at risk, but people have a limitation of liability. Unless you really, if you do something that kills somebody, I mean, maybe that you could have personal liability. But even there, I think the bar is quite high because, at the end of the day, if business can't operate, if we can't innovate, well, then it's almost sort of back to the Stone Ages, right? So you need to have that limitation there. And again, I think there's something there to work out. I understand why people do it, but it feels maybe a little bit recessive.
Yeah, and I guess we're pretty good at fining in the EU. I wonder if we'll see any other versions of this over here. I doubt it, but maybe we'll see more in the States.